I think everybody has an opinion of some kind about the hot mess that is the legal implications of AI, particularly when we're using it to generate content. But I thought it might be a good idea to speak with an actual lawyer about this topic.
Welcome to the AI-powered Thought Leader. This is the show that helps thought leaders and aspiring thought leaders to explore the challenges and contradictions that occur at the intersection of AI and authentic thought leadership. Here is your host, Alistair McDermott.
And I'm delighted to say that Erin Austin is my guest today. Erin, very welcome to the AI Powered Thought Leader.
Very happy to be here. Thank you so much for having me.
So everybody has an opinion about all of this kind of mess that is the legal situation with AI, but you are an actual lawyer, so I'm really glad to talk to you about this. Where are you a lawyer? Where are you based?
Yeah, so I'm in the US. I live outside of Washington, D.C., but I do serve, federal intellectual property laws, federal law. So I do serve clients all over the US.
Awesome. And so your business is called Think Beyond IP, right? So you're
Yes,
the right person to talk to about this.
absolutely.
So this hot mess, as we described it before the show, that is the legal situation with generative AI, where it's taking all of this input in, whatever we're giving it. It's got all this training data that we really don't know exactly where all of that came from and whether it was sourced legally or not. And then it's generating content for us, and then we don't know exactly when that may or may not be copyrightable,
Yes.
and and then we have all of these legal cases. So where should we start?
Yeah, well, when I think about AI and generative AI and how it affects us as experts, as thought leaders, thinking about it from the inputs, like what's going into the black box that is generative AI, and the outputs, what's coming out of that black box. And so, probably, the most notorious and most talked about are the what's going into the training data. When we're talking about those large language models, there is a massive amount of information that is being used to train those models. And so, I'm most familiar with ChatGPT. I know there are others, but there is currently some very famous cases, some involving celebrities like Sarah Silverman. Using her novel, her book, um, but one that has risen to the top and that is very current. And by the time the next person watches this, it may have changed. But as of today, there is a case regarding the New York Times and OpenAI, the company behind ChatGPT, and basically, uh, the training model for ChatGPT is approximately like 4% New York Times content. So they have taken all of their content, and that is just a massive amount. When you think about like the billions of pieces of information that have to be in a training model, and for 4% of it to be from one entity, that is a huge amount, obviously. And so, you know, Chat GBT or OpenAI, takes the position that it is a transformative use and that it's fair use. Obviously, New York Times has a different perspective. And importantly, they did a sample prompt. Granted, the prompt was very directed to get a certain result, but it succeeded in getting an output of an article that was basically word for word the original content. And so that is how they start that conversation. And now the issue is, how much of that was kind of prompt. I wish I remember the term they're using, not prompt fraud, but there's something like that. Like if you're kind of gaming the system in order to get a certain result versus something that would happen organically when someone would naturally just ask a question to chat GPT and it would sort through its billions of pieces of information to come up with a response versus a prompt that is so targeted that it's going to obviously turn up just one source. And so when we think about that training data, the intellectual property issues, and of course, I talk about US intellectual property issues only, is is that an infringement, a copyright infringement to, take that New York Times information, taking Sarah Silverman's book, take scraping the internet, all those things. And is it a copyright infringement? Is it a breach of the terms and conditions of websites? Lots of websites say you can't scrape, and they probably are. We don't know exactly how they do it. Um, and so those are the things that are being litigated right now. From our perspective as users, like we generally, unless you're making your own data set, and I do believe you can do that with certain people are doing their own, but generally, we're not. Our concern is on the output end, but the input issue that does concern us is on the prompts. So we know that, even though they were denying this time last year, that our prompts are also going into that training data. And so what are you putting in your prompts? Like if you're working with the client and you have confidential information, are you putting it in the prompts and that becomes part of the data set? um, or your own, proprietary information that you don't want shared with the world. When I started using ChatGPT first, I'm still just on ChatGPT. I guess I'm a novice AIer. Um, it would say we don't use your your prompts, but we know that it was learning. Like I'd go back and it would know what I did the last time. So it must be remembering and putting my prompts in there somehow. And so now we should assume, everyone should assume, no matter what AI platform you're using, that your prompts may make it into the training data and therefore may be accessible to anyone who has access to that training data. So,
And that opens up a whole can of worms when you're using information and people's data. Like one thing that I do a lot is I transcribe things like this podcast episode. And so some of the tools that I use take this and will actually recognize it. If I put this into Otter right now, this will recognize my voice and your voice, because your voice is recognized by the system because I had you on my other podcast, The Recognized Authority, and
yes.
I tagged your name on there. And so if I then take that transcript and put parts of that or the whole thing into ChatGPT, then it is connecting your name with this, and it could probably figure out who
Mhm.
you actually are based on the context of the conversation. And it could start to build a thing where it has more about you based
Mhm.
on all of this as well. And that's just somewhere where we're having an open conversation in public. The issue is when people are having those conversations, I think, in private, and in particular, like if you're having calls maybe with customers, with clients, and you're taking those, or maybe they're really sensitive conversations about people's personal issues, and one side is recording them and transcribing them and then putting them into AI. We don't really know what's going to end up in those systems.
Yeah, that is such a good point, because people are kind of thinking more about the chat GBTs of the world taking them, but we're using AI all over the place. Lots of us are using an Otter or Fathom or whatever those note takers are when we are recording our Zoom calls or whatever. And that is AI, and it is going into some training data. And if you are, as a lawyer and I'm talking to a client and I'm using one of those, that's very dangerous for me. So I actually don't use them for that reason. Um, and, people love them. I get it. They make these great notes, they have the recordings, and it's fabulous, but you definitely need a consent issue so that your recording obviously will say, well, I'm trying to think of all of them require you to consent to I think they all have that pop up, but that they understand that it's not just like a Zoom call recording, but an AI recording that might go beyond, the two of you. And And so, yeah, we need to think about like all the places that AI is just showing up. Like we've been using it for a while without really thinking about it, but now it's just really part of like almost everything that we're doing, a lot of what we're doing when we are interacting online. So we do need to be really careful about that. Yeah.
One thing that I have done in cases where I have something that's a little bit more sensitive. So, for example, I use Fathom, which is this video recorder that works on Zoom. And
Mhm.
actually, I like the way it actually joins the call as a separate user. And then
Mhm.
it puts Alistair McDermott is recording this call. So it has this really obvious notice that this is happening. And I like
Mhm.
that about like how obvious it is. But in cases where I have recorded a sales call, and I have used this to record sales calls, it's actually super helpful to record your sales calls and then process them with AI, because you're able to use it to help generate proposals. You're
Yeah.
able to use it to improve your sales calls. Like there's a lot of things that are really useful. But what I've done is I've taken the transcript and just run it through a text editor and replaced the person's name with speaker one or speaker two. And it's a
Mhm.
very simple thing, but that may go some way towards helping to kind of obfuscate somebody's identity, which if we're putting this stuff in, I think maybe we should be doing that automatically. We should automatically be hiding the identities of the people who are uh, part of the conversation, unless it's for something like obviously public, like a podcast like we're doing now.
Mhm.
That's something that I think that maybe should become part of how we just do things.
Yeah. Well, I mean, that's interesting. If, like, let's say in the instance of a legal consultation, and if I have a way of disguising my client, and if there's a way for me to do that, I don't know what it is, honestly. Um, I mean, yeah, I can strip it out later, but it's being processed as it's recording. And so that is why I currently am not using it. I was using them because I thought, oh, this is great. And then I'm like, well, hold on, I can't do this. And generally, in the legal industry, it's been recommended that we never use, whether it's the Chat GPTs of the world or the specific legal agreement review type of AI programs, like never have any client information in there. It does not matter. I mean, a lot of those that are specific for the legal industry will say in their terms and conditions that they do not, put any of your inputs into their training data. And still, people, the best practices are just don't do it anyway because you just don't know. So.
Yeah, it's so, and I know, under GDPR here in Europe, like I know that we can't actually use some of these systems. Like we're not actually able to get access, for example, to the paid version of Anthropic's Claude. So I can use the free
Mm.
version, but not the paid version. I'm not able to sign up to it, and I'm not able to use the latest test versions of Google's Gemini, which I really want to get access to. So I use a VPN to come in from a US IP address so that I can test that. And the reason being, I want to test that because it can take up to 1 million tokens, which means it can take about 3 or 4 business books worth of data. And
Wow.
that's
Mhm.
that's really useful to be able to process a large amount of data. So yeah, okay. So we're talking about the inputs being what we put in terms of putting things in like transcriptions with people's names and maybe their personal data, and then and also company information.
Yes.
Like for example, if we go back to the sales call, there might be confidential company information in there as well, which I would hope that somebody would flag if they see, hey, this is
Mhm.
obviously being recorded. Yeah, maybe we need to think about, put policies in place about what do we do when we join a call and we know there's going to be recorded. Maybe we say, actually, we're going to talk about some stuff that we don't want to be recorded.
Right.
We just need to start to kind of bring these processes into place and these kind of procedures. But then the other input is the training data that we as users didn't have any control over. That's Anthropic for their Claude model, Google with all of the data that they have, mountains of data, and OpenAI. And I understand that OpenAI have been training their video model on YouTube data, and I heard on another podcast that Google allowed them to use the YouTube data because Google had already trained their model on YouTube, and they figured, well, maybe if we're all in the same boat, we won't all get in as much trouble. I think.
Well, that's interesting. I mean, because as we move forward, and clearly we're going into a world where we are going to have more AI. And so it's not practical, considering, again, the volume of information that's in these training models. It's not practical to get a license for all this information. But I think generally we think that as a public policy position that it's a good thing, and that I don't think there's any undoing what's happened. Like it's not gonna happen, right? We're not gonna make
it's not going back in the box, no.
Right. So they're not going back in the box. So what kind of kind of mass licensing scheme can we put in place for AI companies to be able to access all this information and use it? In the music industry, and I'm not a music lawyer, but we have these compulsory licenses. So I don't have to get permission from the owner of the music. I can go to these licensing entities, and so long as I pay them, I can use their music. And maybe there's something like that will come about to make sure that there's some protections in place, making sure people are compensated somehow for their participation in the training data. But it's such a massive undertaking. I just don't know exactly how it will shake out.
So if you're talking to somebody and they're wondering about like, what do I need to do at a practical level day to day? What do I need to think about? What's your advice to them?
Yeah, on the input side, make sure that you have a policy in place about how you can and cannot use your generative AI platforms. So if you're using your own data, certainly if this is, if we're as solopreneurs, we make our own decisions. But if we are an employee or an employer, we want to make sure that our employees have clear parameters around what they can use and how and when they can use generative AI. If it is, writing social media posts, fine. But if they're, having an analysis of, okay, we're looking at this issue and we want to help, brainstorm it, then, are there some requirements in place there, or is there a level of approvals required before we put those things through one of these programs, depending on the level of risk and exposure there is. When we are using anything with that's client information, make sure that it is not a breach of the agreement. Some people are starting to include language about the use of AI in their services agreements. And so if it says you can't, use it at all, then you can't use it. And certainly if there's confidential information that you're using, then putting it through a generative AI platform would be a breach of your confidentiality obligation. So we need to be aware of how we are using it on the input side.
And in terms of, let's say a lot of people are going to be using this for content creation, and one of the issues I have with this is it's really blurred when it comes to who owns the output, and we've got the US Supreme Court ruling on this. Actually, can you explain that in layperson's terms for us?
Well, the output side hasn't really changed. I mean, it's always been that in order for something to be eligible for copyright protection, that it has to be created by a human, and has to be original and have a minimum level of creativity. And so the AI is not considered a human. And so depending on, and there's obviously a gray area here, because there's everything from something that is, 100% AI created. And that was the painting that you're talking about. I can't remember the name of it, but where they disclosed that this was 100% AI generated painting. And that was just that's not a human, and therefore it's not eligible for protection. The intellectual property laws in the US are grounded on the idea that we want man, and include women in there, to be rewarded for the fruit of their intellect, and that we want to encourage them to be creative and want to give them a certain period of exclusivity to kind of get a return on that investment. And that is intended to be kind of a right of man as opposed to a right of machine. Famously, there was the photograph taken by a monkey. Like, this was a couple decades ago. And someone tried to, can you copyright that? No, monkeys don't get, no matter how closely related, they don't get rights under intellectual property law. And AI generated works do not get, even if they are as creative, we're going to assume it's still creative, but if it's not created by a human, then it's not eligible for copyright protection. So what has been happening is, okay, we're along the continuum of something that's 100% created and something that's, aided. So let's say you have them generate a outline for you, but then you fill that in, or you have them write the first draft for you and you edit it, or, and so whether or not you're going to have copyright protection for that, whether or not it's copyrightable, kind of depends. And because it is a case by case, there's no percentage, there's no formula. It will be, you are expected to disclose to the Copyright Office, what amount of it is AI generated, and they will make a determination, whether or not the whole work is protectable or just the original human created parts are protectable. And importantly, like, if you try to don't declare that parts of it are AI generated, and then it becomes known later, you can lose their registration, you can lose protection. And so if you are creating content, developing your thought leadership using AI, are you creating something that is protectable? So if you are using it to write a book and then somebody steals your book, do you have a remedy, or is it not copyrightable and therefore in the public domain, and then anyone can use it? So we want to make sure that if that output is something that we want to have exclusive rights to and protected under intellectual property laws, then we want to make sure that we are having sufficient amount of human creativity applied to that work that it would be eligible. So,
And it's subjective.
and it depends, right? It depends.
The best answer. It's because it's always
absolutely.
right. Yes, it
Yeah,
depends.
yeah,
Yeah, because like when I think about this, if you use AI as a pass through. So what I mean by that is, if you say, here's some text, fix the spelling and grammar,
right.
and it does that. Now, it may, unbeknownst to you, it may actually reword some things. When you say that, it can interpret that as remove the passive voice or leave the passive voice, and then things start to change a little bit. And if you gave it large blocks of text, then maybe that's a small percentage. But if you gave it 2 sentences, that may be rewriting 40% of what you wrote. And
That's right.
so there's all like, and then we get into a situation where, like, I use AI with dictation a lot, and I'm giving it my original thinking, or well, this is it. This also then becomes a gray area. Like, what is original thinking? Well, it's
Yeah.
original thinking, but that's because I was speaking with Chris Stowe last night, and I was thinking about what he said, and
Uh-huh.
then kind of my brain synthesized that based on that, and the 200 books I'd read, and then it kind of mixed it
Yeah.
all together. And so is any thinking original? And yeah, if you're interested in that, go check out the previous episode with Chris Doe, because he's coming at it from an artist's perspective and
Right.
a graphic designer's perspective, which is very interesting.
Yeah,
But
from a legal perspective, that hasn't changed. I mean, we've always been influenced by our education, by our experience, by our client work, by the podcasts and what we listen to and the websites that we consume. And so, but putting our own kind of spin on things, regardless of how influenced we are. It's the expression
Mhm.
of these ideas, and ideas are, of course, are not protectable, but our expression of the ideas is what is protected, and that's true still. Yeah.
This it again, it just seems to be such a mess because we don't know, and I think that one of the issues is I think people are just kind of plowing on through it and saying, okay, well, we don't know what's going to happen, and we're just going to keep going forward. That's my my take on it. Do you have any
Well,
thoughts on that?
well, is there any alternative? Right. I mean, at the end of the day, I hope people are taking advantage of the incredible power of AI, and that they're just being mindful about how they're using it. People obsess about a couple of things that I don't think we need to obsess about. One is, um, you know, is AI scraping my website and taking, my work and putting it in there? And again, we think about just the massive amount of information that is in a training data set. Unlike, the New York Times, I mean, like, our, our information is frankly the grain of sand in on the beach, right? And so, I don't want people to get overly obsessed with, is are they scraping my stuff and using it? Okay. And then the other is that now, if it is in there, that somehow people have more access to it than they did before. They have the same access that they ever had with Google. In fact, personally, I think it's much more diluted, than it was with Google. If I put in a search term for, AI powered thought leaders in Google, I'm going to get all of your stuff, all of it. Versus if I put it in a chat GBT, it'll maybe some of your stuff will be in there, but it'll be like scraped. It'll be from all of, the data set is what it's pulling from. And so, I don't want it to stop us from, continuing to, create and not be overly obsessed with, how the AI data sets are using our stuff. That's just my recommendation there. So.
That's that's good advice. I know there's a lot of people kind of afraid of it, and particularly when we see stuff like misinformation and deep fakes and all of this kind of
Oh,
stuff. Do you have any thoughts on those?
yeah, yeah. Well, that is very important for sure. I'll say, like, so this was February 2023 is the first time I ever even heard about ChatGPT. And I was doing a continuing legal education. We have to do these every year to keep our bar membership. And I'm like, to me, AI was like the blockchain of what, I'm like, I'll listen to this thing. I don't even know what it is. And I'm listening and I'm like, what? It can do this? What can it? And so I immediately go to ChatGPT and I'm like, oh my God. And so that was it. That was when the love affair started. But the first time I actually used it, I was looking for an alternative. I had, a citation for New York law, but I needed the similar citation for a different state, South Carolina, I think it was law. So I put in like, I have this thing in New York. I need a similar site under South Carolina. So it spits something out for me. It's got a nice, I'm like, oh, great. And then I'm like, well, let me just read this thing. And it had hallucinated. It completely made up a statute. And so we need to be really careful about how we're using it for things that require accuracy. So it will hallucinate, it will make errors. And so from the legal perspective, we are told to treat anything that comes out of, generative AI as like a junior associate. So you can't just take it and go, thank you, and, send it off to the client or put it in your brief. You need to review it as if it came from someone who really doesn't know very much. And, the way I use it is that I will only use it for something if I already know the answer. Like, I know the answer. I just want you to, like, massage it for me or whatever, but never for, advisory services. Like, never, never, never I would use it that way. And so I would, and you can have the reputational hit, even if it isn't an accuracy issue, but it is, on the output side. There are a couple that will have indemnification for copyright infringement, but most do not. Mostly it's, buyer beware, and you don't know the origin of the output. Like typically, there are no citations. And so what do you have there? And if you are turning that into a client as original work, you're in breach of that client agreement. If you're using it for your own work and it is a copyright infringement, you have both legal issues and reputational issues involved. So we do need to be careful about how we use those outputs.
Yeah, for sure. And
Mhm.
so I think there's two schools of thought on what's going to happen with hallucinations. I think one is that they're going to be able to figure them out and they're going to go away, so don't worry about it too much. And then the other school of thought is actually no, it's kind of baked into how these systems work, because what they do is they generate stuff.
Right.
So
That's
uh,
the whole point of them. Yes, exactly.
so we're gonna need to be really careful about what we put in.
Mhm.
Now, the way that I've dealt with this, and what I found is that the more accurate, the more data I can feed in, the better the output. So, for example, I've created custom GPTs where I've uploaded several of my books and all of my blog posts. And so what I
Mhm.
was able to do is I was able to get that to write some and create some content that sounds like me and has my opinion, which is quite interesting.
Oh, I gotta talk to you about that. That is like my fantasy, is to have one of those. Like
Yeah.
is it called a custom or mini? I forget what they're called.
Custom
Yes.
GPT.
Okay.
Yeah,
Yes.
yeah.
Yes. Yeah.
That's what we're doing, kind of like at the at the independent expert solopreneur type business level. At an enterprise level, they're going to have different solutions where the entire data set can be trained just on their enterprise data.
Mhm.
But those are going to be custom solutions that are going to be very, very expensive.
Mhm.
But for people like you and me, and who have small businesses, small
Mhm.
teams, we don't want to we don't have we don't have the need or the resources
Right.
for something like one of those enterprise systems. But being able to have your own data in there is really, really useful.
Mhm.
And yeah, so I found that very useful for me in again in writing first drafts of things in particular.
Yeah.
And I actually created one which is based on my books about my book and my workbook about podcasts. And I used it while I was driving. I used it in the conversation mode. I just had my headset in. I was talking to
Wow.
ChatGPT on my own custom GPT, and I got it to plan this podcast, including all of the. We actually created some of the graphics.
Wow. I noticed you had AI graphics at the beginning. So yes.
Yeah. So everything on this show is AI generated, and I did that because I kind of felt like I have permission to do that on this show,
Mhm.
and I wanted to experiment a bit with it. But yeah, again, then we get into that whole situation with the copyright. Do I lose copyright to the whole thing because I've got the AI generated section right at the start, and that's
No, you
subjective,
can.
right?
Well, if we just talk about this episode, let's just talk about
Yeah.
this episode. So everything that we are creating here as humans,
Mm.
that is all protectable. Is your opening that if it's all AI generated? No. But if you were to register this episode with the Copyright Office, you would say like it's a podcast episode, and there's like a box where you would say like the part material that's excluded, and you say kind of the images at the beginning, but your protection would apply to everything else. So
Right.
you just take
Okay.
the whole thing out. Yeah.
Interesting. Interesting. Yeah, and I think that a lot of people who are creating content are using the kind of the implied copyright protection just on creation rather than actually contacting the copyright office, right?
Yeah. I mean, think about how much content, how much you make every day, how much I make every day. We don't register most of that stuff.
Mm,
And it's only if, something happens and there's a contest of some sort that it would ever come up, honestly.
right.
Right. So you
Yeah.
go ahead. If you have your AI generated content, do your thing with it, put your copyright notice on there if you want to. And but if you do want to go that extra step of registration, then you really do need to parse it so that you are being honest. Your application, you are making statements that under penalty of perjury that what you're disclosing is correct. But if you're just, it's another social media post or another blog post that you're not registering, just, do your thing. So,
is there anything that I haven't asked you about when it comes to the legal implications of using AI? Anything that we should cover?
Yeah, I mean, just generally, I think going back to the issue of if you're using it to create something that you are being paid for or that you want to be paid for, that is not the works that you want to use AI generated content for, because it may not be protectable. So again, having the copyright protection, the remedies that you have under intellectual property law, that requires it to be, created by a human and original. And so, make your outlines with it, do some brainstorming with it, but the content itself has to be copyrightable. And if you want to build a business from it, like if it's something that you want to license to a third party, can it clear due diligence? Something that you want to sell someday, can it clear due diligence? If you're using AI to create those materials that would be of value to a third party, they have to be original to you and protectable. So that would be mine.
And this is all subjective. Is that right?
Well, it depends on, there is a continuum, right?
Mm-hmm.
But I do believe that most of us have a pretty good idea of how much original we are adding to an outline or to a first draft.
Yeah. I'm thinking specifically of the case that my use case is where I'm dictating something and then I'll have an AI rewrite it. In fact, I might have it rewrite it several times. And so it looks very different, but the original thinking came from me. And I think this one is kind of,
that's
I think
a tough one.
I agree. It's right in the middle. That's where I think it's subjective, right?
Yes. Because we don't know what happened when you put it in and what came out. Like maybe it took what you said and went, oh, I see this article here that's, and then it kicks that back out. So that we don't know. So what I would say is after you have the output, what you do with it between the output and publication is where the originality in creative has to come. So yeah.
And I think for people who are using this day to day, I mean, it's still so new. The output that we're getting right now from tools like ChatGPT 4 it's okay. It's not brilliant. In terms of, I say that and like the wonderful things I could do, it's kind of getting very jaded now in this. Like it's incredible in what it can do. But when we look at the text output that it gives us, it doesn't look like it's quite written by a human yet. And it's certainly like, it's not at the point where I would want to use it directly. I would always want to edit it. So that edit step is really important. And then the amount of input that we gave it is also a big factor here if we want it to be copyrightable. That's what I'm taking from what you said.
Yeah. I mean, and just purely from the thought leadership branding perspective, it needs to be in your voice. Like, so whatever that final product is, you want it to be in your voice. And probably, certainly not today, you're not going to get any output that's going to do that. And so you're going to put that layer on it at minimum.
And that's where the custom GPT that I was talking to you a bit earlier about is quite useful, because if it has, 100,000 words of your writing in your voice already, it's able to use that to figure out how to do more like that. So it can actually get it quite a lot closer. Okay, so input. Careful about what we're putting in, both from a privacy perspective, confidentiality, and having some policies around that, and having like a clear dialogue with clients if we're putting client information in there. Then in terms of output, how we're actually using it, and the level of protection that we have over that output depends really on what we did in terms of input.
Yes, exactly. Exactly.
Yeah.
Yeah. But just
Um,
definitely be careful. I mean, if it's, your social media post of the day, but if it's something that's going into a book or going into a course,
yeah. Right.
yeah.
Right. So maybe we have different levels of kind of uh, different levels of attention, or I'm not quite sure how to articulate that, but we need to
Yeah.
we need to judge each on its own merit.
Yeah. Like, I mean,
Yeah.
I like to look at it if it's like a money maker, a direct money maker, like
Right.
versus if it's, just some marketing material, how evergreen it is, even if it's not a money maker, but it's something that, like a manifesto of some sort that you give away for free, things like that. You want to,
Yeah.
the more valuable it is long term, the more attention you pay to that output.
The other thing you were talking about was policies, and I think it's really important to put in place some kind of policies. Have you talked to people about that, about what they're doing with, internal policies for these things?
Yeah, I mean, I've heard a lot of it has been on the legal side, like how law firms are doing it. Honestly, I'm just starting to have conversations with how kind of the consultant uses it. But that is, kind of next up. I've been like doing some research. It was a very timely conversation today because I have been looking at that. People are asking lots of questions about that. And so I am working on a resource that will help people kind of navigate like the things that they need to be thinking about and how to put those policies in place.
Yeah, and they can find you at thinkbeyondip.com. So I'm sure Erin will have, she has a great newsletter there. Um, okay, so I think this has been fascinating. A little bit scary, of course.
Oh, don't be scared.
It's still I feel like it's still messy, and
Oh, it is for sure. I mean,
it's going to take some time.
there's so many questions to be answered. Like there are more questions than answers, of course.
Yeah,
And so, yeah, we
and
just,
that's going to settle over
mhm,
time, right? As more cases meet the court, as people
mhm.
figure out, more people start using these tools,
Yes.
those will eventually get ironed out.
Yes, exactly. Yeah,
Yeah,
and it depends. I mean, think about fair use. Fair use has been around forever and it's still complete. One court's fair use is another court's infringement. So I don't know we're going to get a better answer than that, but we learn to work with it.
okay, so my takeaway is, we started off and this thing was a bit of a mess. Now it's a little bit of a more organized mess.
My work here is done.
um, Erin Austin, thank you for joining me today on the Powered Thought Leader. It's a
It's
pleasure
been
to
a
chat
pleasure.
with you again. You can, if you're listening to this or watching this, you can find me and Erin. We're both on LinkedIn and very active over there. We both have newsletters. I have a free guide to getting started with AI. If you're just getting started, you can go to learnai.guide. You can find that on there. And definitely sign up for Erin's email list, and she has a great newsletter there that I recommend if you are thinking about using intellectual property in your business.
Which you
So
should.
thanks, which you should be. Erin, thank you so much for being with us today.